Shalom, 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 brothers and sisters. Now, once again, you're under the sounds of the voice of your brother Tazadaq, sure, bay, an aggrieved man. And I'm about to give you some very invaluable information, as I generally do. But I'm about to give you something for educational purposes only, entertainment purposes, or just strictly right knowledge. Right knowledge. This is not legal advice. As you all know, I do not offer legal advice. If you need legal advice, seek yourself a competent counsel and please be advised. I actually titled this video Tazadaq's amazing lawful remedy to get any case dismissed in court or in a colorable court. So this basically is another few of my secrets revealed to you for free, not charging you for this. The only thing that I asked of you is give me approximately 45 minutes to 60 minutes of your time, and I'm going to reveal some information to you that the vast majority of you have actually never heard and no one's ever told you in your life, in your entire life. All I need is about 45 minutes to an hour of your time, and this video will in fact change the way you actually see reality, and perhaps even alter or demise your false perception of reality, because 99% of the things are not what you have actually been taught. You've actually been deceived. So Tazadaq's amazing lawful remedies to get any case dismissed in court is essential. It actually is methods that I've actually used defeating court deceptions and charging the judicial crooks. So I know you want to hear this. The only thing that I asked of you, that when you watch this video 10 to 15 times in repetition. The reason that I'm telling you this is not primarily for video hits on my side. It's to enable this information to be embedded into your subconscious mind, because it's the subconscious mind that we tend to act on rather than the conscious mind. Things that are actually subconsciously embedded into our minds actually become a natural response. So you want to be able to naturally respond correctly with right knowledge. So I ask that you watch this video and that you share this video. And under the video, if you want to make donations, please, by all means, make donations for my time, energy, and research. But I ask that once you watch this video, you share this video at least once, but preferably with as many people as possible. And I would ask that you state the name or the social media name of the person or the man or woman that you shared it with, because I want this video to go around the world. It is very important that the world know this information. That's the only thing that I really ask by you receiving this valuable information that you should rightfully be charged for. So, without further delay, I am going to show you some of the amazing remedies that I've actually used to dismiss various cases in court. Now, the first thing that I ask you is that, are you undergoing some type of judicial proceeding, such as child support, traffic violations, driving without a driver's license, speeding or excessive, or even a criminal proceeding? That's a question. Now, the next thing I want to ask is, did you know that courtrooms actually operate by mass deception? Culpable courts. Governmental agencies and judges routinely trick and deceive people into giving up their rights reserved by the Constitution, that many refer to as constitutional rights, and binding them with policies, regulations, statutes, rules instead of law. So, brothers, sisters, if you watch this video in its entirety by simply giving me, your brother, approximately 45 minutes to approximately an hour of your time, you're going to walk away a different man, a different woman. You're going to walk away with a more realistic perception of reality. You won't be one of the ones that's actually deceived. So what I'm going to talk to you first is about the basic concepts of a trust and a trust law. Because in order to fully comprehend this, you must comprehend a trust. Now, the person who creates the trust is the settlor. Now, when I say person right here, I'm talking in common parlance. When they say person, they're talking about a fiction. They're talking about a corporate construct. They're talking about a straw man because they're speaking in legalese. So, for the sake of this conversation, when I say person, I'm just speaking in common parlance. I'm just referencing a man or a woman. If I'm using person as a fiction, then I'll point that out. So the person who holds the property for another's benefit is the trustee. Remember that. The person who is benefited by the trust is the beneficiary, or the Cestui Que trust. Cestui Que trust, important. Remember that, because I'm going to come back to it. Now, the property that comprises the trust is the trust res, R-E-S, or the corpus, C-O-R-P-U-S, simply the body or something, or the principle, or the subject matter. So let me give you an example. Now, if a mother signs over certain stock to a bank to manage for a son or a daughter, with instructions to give the divided checks to him each year until he becomes the legal age of majority, at which time he or she is to receive all the stock. Then the mother is the settlor. The bank is the trustee, and the stock is the trust. So we have settlor, trustee, and the stock, which is essentially the trust or the rest. And the son or the daughter is the beneficiary who actually receives the stock. So a fiduciary relationship actually exists in law of trust whenever the settlor relies on the trustee and places special confidence in him or her. So the trustee must act in good faith with strict honesty and due regard to protect and serve the interests of the beneficiary. So the trustee also has a fiduciary relationship with the beneficiary of the trust. Well, you said, Tazadaq, what does this have to do with me winning in court? What does this have to me? What does this have to do with me going against child support? What does this have to do with me going against criminal charges? What does this have to do with me going against traffic citations, drivers without a driver's license, etc., etc.? Well, it has everything to do with it. So you just continue to listen and take notes, and then watch it again and again and share the video like I told you at the beginning. Now, a trustee takes legal title to the trust rest. Remember what I said, res was, R-E-S. Which means that the trustee's interest in the property appears to be one of complete ownership and possession. But the trustee does not have the right to receive any benefit from the property. So the right to benefit from the property, known as equitable title, again, that's equitable title, belongs to who? It belongs to the beneficiary. So the terms of the trust are the duties and powers of the trustee, and the rights of the beneficiary conferred by the settlor when he created or she created the trust. Now remember who I said the settlor was. So the state statutes and court decisions govern the law of trust. I'm going to say that again. The state statute and court's decisions govern the law of trust. So the validity of a trust of real property is essentially determined by the law of the state where the property is located. Do you understand? Do you understand? So the law of the state of the permanent residence, I like to use the term domicile, of the settlor, frequently governs a trust of personal property, but courts also consider a number of factors that you are probably not aware of. So listen up, such as the intention of the settlor, the state where the settlor lives, the state where the trustee lives, and the location of the trust property. So when deciding which state has the greatest interest in regulating the trust property. Now, as a general rule, personal property can be held in a trust created orally with your mouth. So be careful. Express trust of real property, however, must be in writing to be enforced. Do you understand? So when a person creates a trust in his will, the resulting testamentary trust will be valid only if the will conforms to the requirements of the state law for the wills. So some states have adopted all or parts of the Uniform Probate Code, which actually governs both wills and testamentary trusts. So now, Tazadaq, oh wait, slow down just a second, my brother. You're confusing me. Now you use this term, Cestui Que trust. What the hell is a Cestui Que trust? Well, pardon my French. Now, that's spelled Cestuiqui, trust. What is it? Well, let me give you some history here. As you know as well, I'm a historian, and sometimes it's imperative to know the history of a thing. So in 1666, that's right, 3 6s. In 1666, in London, during the Black Plague, and why do they call it black? Everything black just has to be bad, right? And then they want to name a man black, but that's another story. And great fires of London Parliament, they enacted an act behind closed doors, and this act was referred to as the Cestui Que Trust Act in 1666. Now, the act was actually being debated, the Cestui Que Trust Act was to actually subrogate the rights of man and woman, meaning all man and all woman were declared dead. I'm going to show you how this whole thing got started. I'm going to give you some history and show you how the damn game is being played on you. And all of you parents, all of you mothers and you fathers that's of the older generation, and tell your children to stay away from this because you done okay in life. You live a little bit comfortably. I mean, your grandchildren are damned unless you get this information. So all man and woman was actually declared dead. Well, a dead body is referred to as a corpse. Am I correct? A corpse is short for corporation. When you're around here moving around in commerce, they considered you to be a corporation. But when the body is dead, they refer to it as a corpse because when you was moving around in commerce, it was considered to be a corporation. Do you understand? So it's considered to be dead, lost at sea, beyond the sea. So, and back then, operating in admiralty law, the law of the sea. So, lost at sea. Now, the state of London took custody of everybody and their property into what is known as a trust. And then the state became the trustee, like the husband holding all the title to the people and the property, until a living man actually comes forward back to reclaim those titles and can also claim damages. And you do this by becoming a secured party creditor. You do this by contacting creditors, debtors, contracts at yahoo.com or going to the website www.creditors-debtors-contracts-and-commerce.org and going to the status correction page and correcting your status. If you haven't corrected your status by now, the question is, what are you waiting for? Do you just love being commercial slaves? What are you waiting for? So you must revoke the power of attorney back. You must alter your status. So the rule of the use of the capital letters used in a name, when capital letters, reused anywhere in a name, this always refers to a legal entity. It always referred to as a fiction, as a company, or as a corporation. There is no exceptions. There is no exceptions. Whenever capital letters are reused in a name, it's always referred to as a legal entity, a straw man, i.e. Tazadaq, Bay, in all capital letters, on your passport, on your driver's license, on your marriage certificate, on your birth certificate, on your gun permit. So the Cestui Que Trust, common term in New Zealand and Australia, or straw man is the common term in the United States or the United Snakes that they've been actually often referred to, and what they've actually become because they slide around in the grass like a damn sneaky, deceptive snake and slowly deprive we, the people, of rights. And they will use incidents like the Pulse nightclub shooting in Orlando, Florida. In Canada is a legal entity, fiction, created and owned by the government, whom actually created. And again, folks, I repeat, owned by the government. You are owned by the government. So right now, Obama is your daddy. If Trump wins the election, Trump is your daddy. If Hillary wins the election, God forbid, Hillary Clinton's your mama. So legally, we were actually considered to be a fiction, a concept, or an idea expressed as a name, which is actually a symbol. So the legal person has no conscience. It is a juristic person, ens leges, a name, word written on a piece of paper. It only exists on paper. This actually traces back to 1666 in London. So London is a state, just like the Vatican is a state. And I know many of you probably don't believe that. Just like Washington, D.C. is a state. So the Crown is an unincorporated association. So why is it unincorporated, Tazadaq? Well, it's private. The Temple Bar is in London, and every lawyer called to the bar swears allegiance to the temple bar. That's right. So even that sister that you saw on SetNet TV that was actually tried to denounce becoming a secured party creditor and status correction, well, she has to do that. She has to pretend that she's for you to win over your votes, but she's really for the bar. Well, I hate to bust your bubbles, brothers and sisters. She's for the bar, and she's sworn allegiance for the bar. And she can't be for the bar and for us as well. See, you can't get called without swearing this allegiance. You can't, brothers and sisters. That is a fact. So the crown already owns North America and everything in it. So your only way out is becoming a secured party creditor. It's doing a status correction to reclaim your dead entity, which is the straw man, which is the corporate construct, which is the fiction that the crown created. Now, you must become the trustee of the Cestui Que trust and remove yourself from maritime admiralty law that holds you in custody, that takes custody of your children, because you yourself is property, and property cannot own property. Now, the subrogation of your rights. So when London burned, the subjugation of man and woman's rights occurred. So the Responsible Act passed the Cestui Que Trust, again, 1666. Wow, what a heck of a year to choose. Meant that all man and all woman of the UK was actually declared dead. So if you're in the UK, this applies to you as well. And lost beyond the sea. So the state took everybody and everybody's property into a trust. This is why I spoke about trust earlier. So the state actually takes control until a living man or a woman comes back and claims their title by proving they are alive and claim the damages that have actually been caused. So this is why you always need representation when involved in legal matters. This is why you always need representation in a child support case, in a DWI case, in a driving under the influence case, in a excessive case, in a child custody case. So the legal fiction is a construct on paper and a state in a trust. So when you get a bill or a summons from a court, it is always in capital letters. But now, mind you, they've gotten a little slick, and sometimes they'll write the first name in lower and uppercase and the last name in all capital letters. But don't be thrown off with the writing, because the more that people become familiarized with this and the more people that's waking up, the more deceptive they've actually become with the writing of the name. So even if your name is not in all capital letters, the game is still being played now. 10 years ago, it wasn't so. But for the most part, when you get a bill or a summons from a court, it is generally in capital letters, similar to a tombstone in graveyards, all capital letters. Why? Because it signifies death. It signifies death. Don't believe me? Go and check it out for yourself. So they are right into the dead legal fiction, not me, the living soul. So a legal fiction was actually created when someone, preferably, usually your mom, who's actually referred to as an informant on the live record of birth, informed the government that there was a new vessel in town based upon your birth. The birth certificate or issue once the live record of birth is generally sent into the Department of Vital Statistics, just as ships are given birth certificates. Do you understand? So your mother has a birth canal, just like a ship. So all this information relates to how the general public are still really legally tied. So through maritime admiralty law, now through this ancient legal construct, we could be easily controlled. You can like that, understand, believe it or not. Now, learning about your legal fiction helps you to unlock yourself. This is why I'm going into some history. Now, otherwise, you are just a vessel floating on the sea, floating on a sea of commerce. And it is possible to be free from financial stress and debt, believe it or not, even in a so-called recession. So mothers and fathers actually become parents, and they are tricked into registering the birth of their babies, who then become children. So in about, I believe it was 1837, the Births, Deaths, and Marriage Act was formed in the UK. And the post of Registers General was established. Now his job, now what was his job, Tazadaq? Come on, Taz, tell me, what was his job? Well, his job was to collect all data from the churches which held the records of birth. Regis, R-E-G-I-S, from queen or crown. Regis, from queen, a crown. Tongue twister right there. Now, all people are seen to be in custody of the crown. So this allows people to function in commerce and to accept the benefits provided by the state. So we are in custody worldwide. Worldwide, folks, under the IMF. So, and that's the International Monetary Fund. But the boys on the block happen to have a different name for it. The International Mother. Well, you know the rest of the story. So the majority of the people are fed, sheltered, and provided for, however now it is in the system. That is benefiting while many are suffering and are poorly fed, housed, and water is contaminated. Now, by the government. Now, many people are now getting sick and are dying as a result of this food, this genetically engineered food. The vast majority of the people are overweight. You're developing all of these health diseases. You're getting these vaccinations, and your children end up autistic. And some of the vaccinations don't even affect you until years later. 20, 30 years down the road, it affects you. A baby's body, a baby brains generally has, receptacles, 3 receptacles in the brain when the baby is born that prevents that baby from getting sick. When you allow your baby to get those vaccinations, it affects those receptacles and your baby gets sick. Your baby gets sick. So you're contributing to the sickness of your baby. And some of them end up with Alzheimer's. Some of them end up with Parkinson's disease later on in life. And some of them end up with autism very soon after the shot. But don't believe me? Do some research and go and check it out for yourself, because that's what I do with the vast majority of my time is research. You're watching the game, Tazadaq is researching. You're playing Xbox, Tazadaq is researching. You're chasing skirts, Tazadaq is researching. So many people are now getting sick and dying as a result of this, not to mention that as people evolve, they now seek to be independent of the system that seeks to control or oppress and harm the earth that is actually taking place as I speak. So we have legally elected representatives. We have to understand who we are as a man and a woman and how we can relate in the system. Now, for example, the city of London is a centre for markets where merchants work. then there is a mercantile law. So it comes from maritime admiralty. Now, I want you to look at the symbol in the city of London, because this is where this trust madness started. Excuse me. In the city of London, that relates to maritime admiralty. Now, the national banks are not our banks. The private shareholders from the private banks own the bank, these banksters. It is all private, not public, as we are led to falsely believe. It is not public. Now, of is a very important word to remember. It also means without. Of also means without. So the bank, without England, private banks issue private currency. So with World War II, a change actually occurred. While money was not backed by gold or silver anymore, it is now based on people's labor. So people are now pledged to the International Monetary Fund as the surety to pay back the creditor in the global bankruptcy. So man and woman are not bankrupt. They are the only source of credit. We, the people, the public is bankrupt. The public is bankrupt. Now, regarding the currency that gets issued at the Bank of England, people are the gold or the treasure. The government issues bonds or treasury bills that are bought by investors. The money goes back into the economy in order to pay for the people to build things, i.e. the Olympic stadiums, Yankee Stadium, and so on and so forth. However, the people are paying taxes for the privilege of using someone else's currency and paying back the principal and the interest on the original loan that was given against the treasury bonds. So bills and notes. It is a private corporation, folks, that will own the Olympic stadiums, that will be responsible for running it, that will be able to sell commercial rights. Yet, we, the people, are actually the ones who own it and should be profiting from it, rightfully so. However, principal and interest is actually coming through the people in order to raise the money. So when you have commercial, or when you have commerce, should I say, and money, you also have justice. But right now you have just us. You need to understand that bankruptcy before you can actually understand judiciary. So you need to accept the bankruptcy, and we have accepted the claim to accept the summons. So this is an obligation to accept any liability which has actually been created. All you could do is accept the bankruptcy, folks. That's all you could do. Now, we are actually operating in maritime admiralty law. So knowing such a not guilty plea dishonors the bankruptcy. That's a lie. And if you believe that, you will deceive. A not guilty plea dishonors the bankruptcy. Oh, Tazadaq, what are you talking about? No, that's the truth. See, you don't know which way to go, folks. But in real truth, a not guilty plea, when you go in to one of these colorable courts and say you're not guilty, it dishonors the bankruptcy. So the straw man, also known as the legal fiction, is always guilty. Understand that. The straw man is always guilty. It needs to be accepted for value. Now, barristers and solicitors are making a living out of creating controversy, getting you in the court and arguing. By creating controversy, you become liable for the case. Do you understand? Well, Tazadaq, what do you mean? Oh, you're going to the left. Well, let me explain honor and dishonor. So to remain in honor, you have to accept a claim and then settle it for informational purposes only. You meaning I. So then, because I'm not giving legal advice, and for the record, this is not legal advice. I do not offer legal advice. Nothing in this video up to this point has been given or provided for legal advice. It's purely for educational, informational, and entertainment purposes only. If you decide to use any of this and fall flat on your face, you can only blame yourself, because I do not provide legal advice of any kind. Now let's get back to the lessons. So to remain in honor, you have to accept the claim and then settle it. I have to do that. Then you add conditions. I conditionally accept your offer upon proof of claim and proof of loss. So this actually gives liability back to them. The legal fiction is always guilty, folks, always guilty. So only in high courts can the real man or real woman appear. There's only one high court, it's the Supreme Court. So games are being played on courts. So therefore, the name court is a game. Court is a game. Well, Tazadaq, what do you mean court is a game? Well, it's a game. Just like a tennis court. Just like a basketball court. It's all played on a court because it's a game. So when they invite you in, it's a game. You're part of the game. It's an act. It's all an act. And everyone has on a costume. Just like on a basketball court, they have on a costume. They have on what they refer to as a basketball uniform. On a tennis court, they have on a costume. On a golf court, they have on the official golf wear and so on and so forth. So in court, the black robe has on his priest costume. The bailiff have on his costume and a gun to intimidate you. It is called court because it is a game with actors acting on acts. It has actually been treated as a game and just business. Courtroom dramas are misinformation. So in the public, we are operating in bankruptcy and you receive benefits. So it takes a lot of time, effort, and study to use the information that I facilitate. You can't just do this overnight. Get your minds right, brothers, sisters. See, you have actually to be prepared to go fully through the process to get the right knowledge and tools from your toolbox at the right time, or you're going to go in dishonor and you're going to get slam dunk. So people need to learn how to act as creditors. And the way to do that is to become a secured party creditor. Again, visit the website, www.creditorsdebtorscontractsandcommerce.org. Go to the status correction page or email us at creditorsdebtorscontracts@yahoo.com. So to sum up what I've said thus far, money is backed by labor now, not gold or silver. We cannot exchange in a fairly for gold or silver. Can't do it anymore. Capitalization of your name means a dead entity or a legal fiction or a corporate construct or a straw man. So, know who you are. Know that you're not a straw man or a dead fiction or a fictitious entity, and learn how to become a secured party creditor by contacting us now. Now, this is very important, so I want you to listen up. And again, I ask that you share this video, and under the video, if you, the only comment that I really ask you to leave is who you shared the video with. This video needs to go around the world. Now, this is important. This is important. And I wish you all the best if you decide to use any of this information. And again, contact us. Contact us. Now, this has actually merely been an intro into the ideas of how your entity, your straw man, Your all caps name was actually created in 1666, an act of parliament created during the Black Plague and Great Fires of London behind closed doors, which was actually called the Cestui Que Trust, again, in 1666. So, again, the act was being debated was to subrogate the rights of man and woman, meaning all man and woman was actually declared dead. Now, the land of the free. You're only going to be in the land of the free here. This is the only land of the free left, is your mind. Get your minds right. Who's who? And what should one say, Tazadaq? Well, my position, Tazadaq Shah Bey, an aggrieved man, intervener, the authorized representative on going to court, has always been, I never voluntarily go into a culpable court. A live man, a living soul, a live woman are not meant to be in any place designed solely for the business of all fictional entities. So when I attend court, I know I am deemed dead. In fact, they cannot deal with me or you until I admit to being dead, i.e. a legal fiction, a trust. So court is for title persons: judge, prosecutor, defendant, bailiff, cops, attorneys. A live man and a live woman are not recognized. So it makes sense to send in a dead person. Do you understand? An attorney to handle our cases. Except for one thing. They do not know how the system works due to their indoctrination. See, their minds are warped also. The average attorney was calling me crazy. He would call me a lunatic. So if you could actually find an attorney to do as you say, then for entertainment purposes, then you will actually prevail. But most of them would rather hang on to the bar cards than behave honorably. So the only thing that the dead fictional entities want from we, the people, is our life energy. And the only way they can get it is by our consent, by our agreement, or by acquiescence. And acquiescence is agreement. So without us, they cannot function. They are desperate to get us into their culpable courts to have us pay the debt which they created by charging the trust. Now, since common law courts primarily no longer exist, we know that the case never has anything to do with the facts. The facts are on the moon. It has nothing to do with me, the living soul, or you, the living woman. And so anyone who testifies, meaning talk about the facts of the case, is doomed. I've always stated the facts are on the moon, and they are. So all courts operate in trust law. I'm about to drop something heavy on you now. So based upon ecclesiastical canon law, and you wonder why Tazadaq keeps his head in the scripture, in the Torah. It is based upon canon law, ritualism, superstition, Satanism. So, which actually manifests as insidious commercial law, and we are actually in court to take the hit. So, if they can get us to do so, they use every trick in the book. They use intimidation. They use fear. They use threat. They ridicule you. They use rage and even recesses in order to change the jurisdiction when they know they're actually losing the court will be adjourned so they could actually change the jurisdiction in order to make us admit that we are actually the name of the trust. So when they do so, we're doomed to be the trustee. I don't want to be the trustee. So the one liable for administering the trust is the trustee. So until now, folks, it has been a waste of our time, energy, and emotions to go into a public place where it's almost certain that we will be stuck with the liability. But then you have Tazadaq Shabay and a aggrieved man teaching right knowledge and facilitating information. So we all know from our indoctrination, from our programming, and you have the deprogram enlightener, aka Tazadaq, because I've been deprogrammed and now I enlighten. And from your schooling that judges are impartial and have sworn an oath to this effect. So this means he must not favor either plaintiff or defendant. But our experience, if you've been to court, actually reveals that he does indeed favor the plaintiff. So indicating a glaring conflict of the entrance. So the prosecutor or the prosecutor, judge, and the clerk all work for the state. Understand that. So the owner of the Cestui Que trust is the state. So as the case is not about justice, it's about just us paying what they want us to pay. So it must be about the administration of the trust. They all represent the trust owned by the state. And if we are the beneficiaries, the only two positions left are the trustee and the executor. So if you detect that the judge is partially, although I doubt the case will get this far, you might just want to let them know that you know what's going on, that you know this. So if you consider court as an entertainment, and if you can actually stand the evil emanating from its officers, the fear and the overwhelming confidence oozing from the walls of their bodies and the treacherous atmosphere, then go in knowing that under trust law, we cannot be the trustee or the executor of the trust. So being beneficiary, as that would be a conflict. We can't be that while being beneficiary, or that would be a conflict. So the position of the beneficiary may lack clout, but the other position actually holds liability. Let me explain. Now, since the state employees want to be the beneficiaries of the trust, the only way that they could do so is to transfer to us the liability which they hold as trustee and executors, because they are also, or should I say, they also cannot be both administrator and beneficiary of the trust. So the trustee and the executor, i.e., the suretyship, becomes a hot potato. Hey, no one wants it. Hey, I don't want this. The suretyship keeps getting passed around. No one wants it. So the trustee and the executor, aka the suretyship, becomes a hot potato, and everyone wants to toss it so he can be beneficiary of the credit from the trust. Do you understand? Do you understand? So when we are bought into this world, when we are born, a trust called a Cestui Que trust, or for short CQ, was set up for our benefit. Now, evidence of this is the birth certificate. But what is the value which must be conveyed to the trust in order to create it? That's the question. So it was our right to property via the birth into this world, our body via the live record of birth, and our souls via the creation from the creator. Since the state or the providence which registered the trust is the owner, they own the birth certificate, it is also the trustee. Watch this, watch this. The trustee is the one that administers the trust. Watch this. So since they also wanted to be beneficiary of this trust, they had to come up with ways to get us as beneficiaries to authorize their charging the trust allegedly for our benefits via signature on a document, citation, application, etc., etc., etc. Otherwise, by way of a contract. And then temporarily transfer the trusteeship to us during the brief time that they want to be the beneficiary of a particular constructed trust. See, this is how the game is played, folks. So what this means is that a trust can be established anywhere, anytime, and the parties of the trust are actually quickly, albeit temporary, put into place. But since a beneficiary cannot change a trust, only a trustee can do so. It is the state that actually changes the trust, but they also, for their benefit, not ours, albeit occasionally, we do reap some of the benefit from the charge, but nowhere near the value which they reap. So I want you to think bank loan. We reap a minute percentage of what they gain from our authorization. So the only way under trust law for them to be able to charge the trust is to get the authorization from the beneficiary, who is initially us. And the only way for them to benefit from their charge is to get us to switch roles from the beneficiary to the trustee. Do you understand? The trustee is the one who's responsible for the accounting. And for them to switch their role from trustee to the beneficiary, because no party can be both. Remember that. So at the same time, within the same constructed trust, no party can be both. So they must somehow trick us into accepting the role of trustee. Now, why would we do so when the trust is from our benefit? Why would we do this? And how do they manage to get us to do this? Well, the best way is in a courtroom and trick us into unwittingly doing so. So, but, if we know what has transpired prior to our being there, and you do because you're watching this video and you're going to share it, and this video is going to go around the world, it is easy to know what to say so this does not happen because of right knowledge. And this is actually only for entertainment purposes only. It's just information. I'm not telling you to do anything. I'm just showing you methods that I've effectively used. So the court clerk is in the hot seat. He's the hot shot. Now, even though it appears as if the judge is, it's really the court clerk. So the clerk is the trustee for the Cestui Que trust owned by the state or the providence. And it is he who is responsible for appointing the trustee and the executor for a constructed trust. That particular court case. Do you understand? So the court clerk appoints the judge as trustee. Now that's the one to administer the trust, and appoints the prosecutor or the prosecutor as executor of the trust. The executor is ultimately liable for the charge because it was he or she who brought the case into the court. He actually created the constructed trust on behalf of the state or the providence, which actually charged the Cestui Que trust. So only the executor or the prosecutor can initiate or create a constructed trust. And or should I say, a maxim of law. What's the maxim of law? What is it? I can't recall it at this time. Because we should all know this maxim of law. Or that's what it is. Whoever creates the controversy holds the liability. That's a maxim of law. Whoever creates the controversy holds the liability, and whoever holds the liability must provide the remedy. That's a maxim of law. So this is why all attorneys are mandated to bring the checkbooks to the court, because if it all goes wrong for them, meaning either they fail to transfer the liability onto the alleged defendant, or the alleged defendant does not accept the offer of the liability, then someone has to credit the trust account in order to set off the debt. Since the prosecutor is the one who actually issued the bogus papers and charges the trust, it is the prosecutor, which is the executor, who is in the hot seat. So watch this. So when the name of the trust, i.e. John Doe, is called, the judge, aka the administrator, or the trustee. So we'll refer to him as JAT, because judge, also known as the administrator, and also known as trustee, JAT, judge, administrator, trustee. We can stand and ask, are you saying that the trust which you are now administering is Tazadaq Shah Bay Trust? So what does this do? This actually established that I know that the name is a trust, not a living man. So what the JAT, aka the Judge Administrator Trust, what's his first question? His first question is generally, what is your name? Or state your name for the record. So, brothers and sisters, this is why we must be very careful not to identify with the name of the trust, because in doing so makes us trustee for entertainment purposes only. So what does this tell you about the black robe, about the judge? So if we know that the judge is the trustee, then we also know that the judge is the name, but only for this particular constructed trust, only for this case. Now I want you to think about it. All the times the JAT, the judge, the administrator, the trustee, has become so frustrated by only refusal to admit to being the name that they use, and they issue a warrant to this name, and they must feel foolish for saying Tazadaq Shah Bay is not in court. So I'm issuing a warrant, because I want you to be aware of that. If you don't refer to yourselves as the name, I, sit in many courts and I watch them, a man goes in and stands up and assert his rights, and they say, well, if Tazadaq Shah here today, well, I'm his authorized representative. Well, if Tazadaq is not in court today, I'm going to issue a warrant for his arrest. You see that? That's semantics, that's deception, and that is wicked as hell. That is wicked as hell. Because the judge is the name. He's the trustee. He's the trustee. He's the administrator. So, now, because I did not submit to being the name, they threatened to issue a warrant. Then as soon as the man leaves, the man is arrested. It hasn't happened to me, but I know brothers that it's actually happened to. But how idiotic is that? They must feel foolish for saying Tazadaq Shah Bay is not in court, so I'm issuing a warrant for his arrest. And then the man whom they just admitted is not there is arrested. Do you understand? So that's easily defeated. This is why they've never been able to get me. Hold on. You just admitted that I wasn't here, because I said that I'm the authorized representative, and the black robe says, well, if Tazadaq is not in court today, I'm going to issue a warrant for his arrest. Okay, well then go ahead out there and find Tazadaq Shabe, because you know it's not me. You just admitted that it's not me. You said you're going to issue a warrant for his arrest, not mine. So they've never been able to get me on that, because I am the living soul. I'm not the man. I'm not the name. Do you understand? Do you understand? Do you understand? So this is desperation, folks. And their desperation makes them insane. So they must get us to admit to being the name, or they pay. And we must not accept their coercion, or if we do, we pay. Because the JAT, the judge, the administrator, the trustee, is the trustee. Do you understand? Do you understand? Oh, wow. What a crazy position to be in. But the best thing to say for informational purposes in that case, Tazadaq Shabe is indeed in court. And then I point to the judge or the administrator or the trustee. It's you. You're Tazadaq Shabe. You're the trustee. You're the administrator. You are Tazadaq Shabe today, aren't you? You see that? Now, and this would actually cause frustration, because now the truth is being brought forth. So during their frustration over mine not admitting to being the trust name, the trustee, or the executor of the trust, now I ought to ask, who are you? Who are you? And before we go any further, I need to know who you are. Then I address the clerk of the court, the trustee for the Cestui Que Trust owned by the state Providence, or you, the Cestui Que trustee, who has appointed this judge to administer and trustee of this constructed trust, case number 678-910, for example. Did you also appoint the prosecutor as the executor to this constructed trust? See, now I'm talking to the court clerk, because he appointed the judge, trustee, and appointed the attorney, executor. Understand that. So then I point to the black robe, the judge, the administrator, the trustee. It's all one. That's the jack. So you are the trustee. Then I point to the prosecutor and say, you are the executor and I am the beneficiary. So now we know who's who. And as beneficiary, I authorize you to handle the accounting and absorb this constructed trust. I now claim my body, so I am collapsing the Cestui Que Trust, which you have charged. And as there is no value in it, you have committed fraud against all laws. So likely, we will not get that far before the robe or the jack, the judge, administrative trustee, will order case dismiss. Or even more likely, as he clings tightly, this executor or the prosecutor, as he clings tightly to his checkbook, will call, we withdraw the charges. Do you understand? So, brothers and sisters, what I just did is have exposed the fraud of the Cestui Que Trust. It's not my duty to expose the fraud, which exists only on presumption. They operate on presumption and assumption. They presume you to be like everyone else. The Cestui Que Trust has no corpus. It has no property. It has no value. Trusts are actually created upon the conveyance of property and can only exist only as long as there is value in a trust. But there is no value in the Cestui Que Trust, yet they continue to charge the trust. This is a fraud, folks. This is a fraud. So the alleged property is we, man or woman, whom they have deemed to be incompetent wards of the state, dead, abandoned, lost at sea, bankrupt, or minors. But that is an illusion. So if we claim our body, then we collapse the presumption that the trust has value. So they are actually operating in fraud once we claim our body. Something we've always known, but we have never known how they do it. But now you know. And again, share this video, and I ask under the video, you list who you shared this video with. Our having exposed the fraud gives them only 3 options. What's the 3 options? Number 1, they can dissolve the Cestui Que trust, the one for which the clerk of the court is trustee, and from which he created a constructed trust, the case for which he appointed the judge and the prosecutor, titles which hold temporary liability, the judge being the trustee and the prosecutor as the executor. Now, respectively, they cannot dissolve the Cestui Que trust, or the entire global system would actually collapse, because they cannot exist without our energy, which they obtain via the Cestui Que trust. Number 2, they can actually enforce the existent rule of trust, which means as trustee, they can actually set off the debt and leave us alone. They may want to take that option. Now that they know that we are on to their deception, and every time they go into a court to administer a trust account, they will not know if we are the one who will send them to jail. Do you understand? So the trustee, which is the robe or the judge, is actually the liable party who will go to jail. And the executor, which is the prosecutor, is the one who enforces this. This is why they want us to take on both titles, because then not only do we go to jail, but also by signing their papers, we become executor and enforce our own sentence. Do you understand? So they cannot afford to violate the ecclesiastical canon laws out of fear of ending their careers. So they are again trapped with no place to run. And the third thing is they can dismiss the case before they even take the risk of exposing their fraud. So, which also makes no sense, because then the careers again become to a screeching halt. So, what's a court clerk to do, Tazadaq? Well, pretty soon, none of these thugs will take any case, because the risk will be too great. The more people that become educated. And that's why a video like this is dangerous. That's why a man like Tazadaq Shah Bey in their midst is dangerous. And that's why if I mysteriously disappear, you would know that I was actually assassinated by some governmental agent, some CIA member, or some FBI member, or perhaps even one of their law enforcement. But hey, every day I'm putting my life on the line. And if they kill me, I die for a worthy purpose. So this will end their deception, and it will be the end of the court system. Brothers and sisters, not knowledge is power. The way that you apply knowledge is power. Do you understand? So this means by which we have attempted to, apply knowledge, and how the powers that be inflict their powers on us, and this superficial deception that they've actually applied upon us won't stand if right knowledge is presented. Now, system can create penalties, as this is actually trading or using property of a corporation. we do not own. The birth certificate proves that the name is in fact the property of the corporation which issues it. We can do all the paper perfectly, but in the end, they say, sorry, you're not one of us. But now, we get into being fearful of them. They inflict fear onto us when it should be the other way around. So when we are forced to court, knowing that the judge acts as the trustee and the prosecutor acts as the executor of a Cestui Que trust is very empowering. It gives us two choices. Number one, if we wish to expose the fraud, a presumption by which the Cestui Que trust still exists, then the court is the perfect opportunity to have them dissolve or to prove the fraud, because a trustee is sitting on the bench, which is the bank. So, dissolving the first Cestui Que trust, it dissolves them all. Now, number two, if we are not inclined to use something like the ecclesiastical depot to expose the fraud of the Cestui Que trust, then at least we ought to know that everything the judge says, even if it sounds like a command, order, or sentence, is actually an offer which we can choose to decline. I do not consent. I do not accept your offer, or I conditionally accept your offer upon proof of claim. This is the fundamental principle, folks, of the testamentary trust. The beneficiary can accept or decline what the trustee offers. Now, brothers and sisters, for about 10 or 11 years now, I've researched, I've studied, and watched these alleged solutions in commercial come and go, and many of their tactics have not worked. It has not worked for enough people. On some occasions, it has worked. But, brothers and sisters, when you go in as a man. When you stand as a man. The first trust of the world, Unam Sanctam, is one of the most frightening documents of history, and the one most quoted as the primary document of the popes claiming their global power. It is an express trust deed. So the last line reads, and I quote, "Furthermore, we declared, we proclaim, we define that it is absolutely necessary for salvation that every human creature be subject to Roman pontiff." End of quote. So, brothers and sisters, it is not only the first trust deed in history, but also the largest trust ever conceived, as it claims the whole planet and everything on it conveyed in a trust. Now, the triple crown of Baal, aka the papal tiara, in 1302, the Pope Boniface issued in his famous Papabellum, the first express trust. The question is, now that you've heard this information, now that you know this information, the question is, what will you do with the information? Since 1933, when a child is actually born in a state, which is really an estate, under the inferior Roman law, 3 Cestui Que trusts are created upon certain presumptions specifically designed to deny forever the child any rights of real property, any rights to be free, and any rights to be known as a man or woman rather than a creature or an animal, by claiming possession of their soul and their spirit. The executors or administrators of the higher estate willingly and knowingly convey the benefit entitlements of the child as beneficiary into the first Cestui Que trust. in the form of a registry number by registering the name, thereby also creating the corporate person, the storeman, and denying the child any right to the real property. And the second thing is they claim the baby as chattel to the estate. So the slave baby contract is then created by honoring the ancient tradition of either having the ink impression of the baby's feet onto the live record of birth or a drop of its blood, as well as tricking the parents to signing baby away through the deceitful legal meaning of the live record of birth, which is a promissory note converted into a slave bond sold to the private reserve bank of the estate and then conveyed into the second separate Cestui Que trust per child owned by the bank. So when the promissory note reaches maturity and the bank is unable to seize the slave child as a maritime lien, is lawfully issued to salvage the lost property and is actually monetized as currency is issued in series against the Cestui Que trust. And the third thing is they claim the child's soul via some baptismal certificate. And since 1540, the creation of the first Cestui Que Trust Act deriving its power from the Papal Bull of the Roman court leader, the Pope III, in 1540, when a child is baptized and a baptismal certificate is issued, the parents have actually gifted, granted, and conveyed the soul of the baby to a third Cestui Que trust owned by the Roman cult, which was actually held this valuable property in its vaults ever since. So since 1815, the third crown of the Roman court and the third Cestui Que trust representing the ecclesiastical property has actually been managed by the bar as the reconstructed gala responsible for the grim reapers for reaping the souls. So each Cestui Que trust created since 1933 represents one of the three crowns, the three claims of property of the Roman cult. Real property, which is on earth; personal property, is the body; and ecclesiastical property, the soul. Each corresponds exactly to the three forms of law available to the gala of the bar courts. The corporate commercial law. The judge is the landlord. Maritime and canon law judge is the banker. And the Talmudic judge, or the Talmudic law judge, is the priest. So what is the power of a court judge? Tazadaq. Well, given what has been revealed in this video thus far about the foundation of the Roman law, what is the real hidden power of a judge when we face court? Is it their superior knowledge of the process and procedure, or their magic? Or is it something simpler and far more obvious? Well, it is unfortunate that much of the excitement about the estates and the executors has deliberately not revealed that an estate, by definition, has to belong to a trust, to be specific. So a testamentary trust or a Cestui Que trust. So when we receive legal paper or have to appear in court, it is these same Cestui Que trusts which have our rights converted into property contained within them. So instead of being the trustee or the executor or the administrator, we are merely the beneficiary of each Cestui Que trust, granted only beneficiary and equitable use of certain property, never legal title. So if the Roman legal system assumes we are merely beneficiaries of the Cestui Que trust, when we go to court, who represents the trustee and the office of the executor is the question. So we all know that all cases are based upon the judge's discretion, which often defines procedures, statutes, and maxims of law. Well, they are doing what any trustee or executor administering a trust in the presence of the beneficiary can do under Roman law and all of the statutes, maxims, and procedures, and really show, because under the principles of the trust law, as first formed by the Roman court, a trustee has a wide latitude, including the ability to correct the procedures, the mistakes, by obtaining the implied or tacit consent of the beneficiary to obliterate any mistakes. So the judge is the real legal name. The judge is the trust itself. We are the mirror image to them, the ghosts, the dead. So it is high sorcery, folks. It is trickery that remains legal far too long. So I only ask that you share this video, you spread the word. This video needs to go around the world. This video needs to spread around the world. Under this video, in the comment section, say I shared this video, and then you list the person that you shared it with. And an addendum to court. Roles of parties to the trust. If we act as anything other than the beneficiary of the Cestui Que trust, folks, we could assist in settling these matters. But as the clerk is the trustee of the Cestui Que trust, he or she appoints the judge as the trustee and the prosecutor as the executor of the constructed trust of case number 8, 9, 10. So it is their job to settle the accountant. The prosecutor changes the trust account, or should I say they charge it, and created the debt. So it is he or she who is liable for paying or repaying the balancing of it. So they break their own rules, folks. They break their own rules by their fraud of failing to perform their duties, saying, I will appeal this as a matter of law to a higher court if the court rules are broken, means the judge won't get his commission based upon the fraud. Now, as far as trusteeship is concerned, since no one can be trustee of both the Cestui Que trust and the constructed trust at the same time, they do a bait and switch. They use the Cestui Que trust to create a temporary constructed trust, which is the case. So the matter case, or the matter, whatever you want to call it, is a trust apart from, but attached to the Cestui Que trust. Now, the bonds are added to the constructed trust at the clerk's office. Now, there's 3 forms of court. You have UCC, which is equity, commercial. It's all about property rights. You have maritime amity, canon. Only now can the judge cite for contempt, impose fines, jail time, etc., etc. Only in a maritime amity court. And you have Talmud. This is where the judge returns as priest. Now, most do not go this far, as by now he already knows that we know. So he knows it's over for him. And before I go, recess. Sometimes they call it recess. So when the judge calls for a recess, it means he's going for a bigger stick. He's going to come back and try and slam dunk you. So he intends to change the courts. So what I say, if they call for a recess, I do not consent to the form of court being changed. So for the record, on the record, and let the record show, I object to the judge changing the form of court from equity to canon to amity and so on and so forth. So if you insist, I'll reassert my rights upon your return. Now, foreclosure. A lot of you dealing with foreclosure. The clerk is the senior ecclesiastical officer in a foreclosure case and can assign title over to the bank. So we are a tenant. The mortgage is the lien or the lease or the loan. We do not and cannot own anything. The bank does not want us to pay the mortgage, which is the entrance, aka the rent, because they want us to be in delinquent. They want us to be incompetent in performance, which is the main point of the contract. So in order that we lose our claim, so we pay some of the rent, even if it's only $50 a month. We change our status from delinquent to competent, and this allows us to remain in honor, which is the entire matter. So they do not want us to behave honorably, folks. The bank, which is the court, because the judge sits on the bench, cannot force us to leave our property, yet we must adhere to address our standing. Then we can actually use their procedures against them. We must challenge the Cestui Que trust. It goes back to the Cestui Que trust. Now, if one gets to court, say for foreclosure, as a tenant in this matter, with only rights of use of property, I ask for a stay, as I have actually exhausted my administrative options. So we can do this in order to buy time to do an ecclesiastical depot, EDP, on original issue. Now, through the clerk or the trustee of the Cestui Que trust or the chaplain of the court, they must forgive in open court, or they have lost the ecclesiastical authority. Now, an old friend once told me, that he watched someone tell the attorney for the bank. So just so you know, we'll be coming in at a superior property holder competent position, and we will know and understand the three forms of court. And it is said that the attorney pleaded at her, screamed at her, raged at her, yelled at her. One more thing I want to, before I close this out, I want to deal with a plea. So when asked, how do I plea? I generally say I wish to ask as a matter of law, or you presiding as trustee of this matter, the constructed trust of case number 678-910, if a negative response is given without seeking any appeal to another court as a matter of law, if I merely ask, or you presiding as administrator of a Cestui Que trust from which the constructed trust is created. See, these are the questions that I ask when they ask me, how do I plea? And it's not good to mention contract because they do not have a contract. So without our parents, which is how the Cestui Que trust was created, they don't have a contract with me. But what about jail, Tazadaq? They want to lock me up. See, there are three Cestui Que trust names: the flush, the soul, and the name. Now, due to this, we have no property rights, so they can lawfully hold us. But if a friend of one who is incarcerated establishes himself as competent, he can demand that his property be returned. So he changes his standing and demands his property returned, as he has a higher claim. Or if the friend can send in an ecclesiastical deed poll, so at the hearing, the ecclesiastical deed poll is in the court. As a friend of the court, I seek to leave of the court so my friend can be complete, or my friend can actually be complete or complete this ecclesiastical deed poll witnessed by the court. And if declined, I seek leave of the court for an appeal on a matter of law that you are permitting this man a fair defense and to establish his standing. And I know, brothers and sisters, of someone who is actually being transported from one jail to a prison, and when he arrived, he was asked for his name. Now, as a body, he was worthless to them. They needed the name, and they needed him to be the name. So he surprised them by saying, if you do not know who I am, how can you imprison me? And they let him go because he refused to give them the name of the account which they intended to charge against, which to float the bond. Now, this is a true story. Tazadaq, you mentioned ecclesiastical deed poll. What is it? Well, ecclesiastical deed poll, all matters are about property and trust. So the ecclesiastical deed poll, or the EDP, establishes us as property holders, and so then we have rights and can claim our property. So whether it is our friend in jail or our homes, or they have actually left, is your fear. These are the powers that they have over you. Is force, fear, threats, and intimidation. Why? Because they are criminals, they're pirates, they're parasites. And paper, as far as paper attacks, attacking commercial, attacking commerce commercially from the level of commerce is a powerless virtue. Since 1983, canon law is our paper, which condemns us. Excuse me. So the only paper which will work for us is knowing how to handle a contract, ecclesiastical deed polls, process, and our thumbprint, our right thumbprint in red ink, and to apply it for that effectively, you must understand contract law. As far as vehicles are concerned, I just recently went over to the driver motor vehicle because I still operate in commerce. I got a driver's license and I reserved my rights. When I signed the name, I also signed all rights reserved, UCC 1-308. So, and if I go down and register and put up the certificate of title and ask who owns the vehicle represented by this, she will usually look at me and read, well, Tazadaq Shabe. And then I ask, who owns Tazadaq Shabe? It's trust. And the lady didn't know, so I told her it is owned by the state or the province of New York. So how do I know this? Because this birth certificate document proves it. And since the owner of anything is always the trustee, and the trustee is always liable party, then the owner always pays. So if A equals B and B equals C, then A equals C. So accordingly, since the vehicle is actually owned by the state, then the state of New York is the one which must pay for the insurance, for the registration, the taxes, etc. You can enforce this if you know contract law good enough. You could do it. I'm not telling you to do it, but you can. So if you claim I am inaccurate or that I am the one liable to pay, then you'll have to prove it. Understand that. So we could just pay, or we could just put the titles of our cars into the name of the state or the providence, as it already owns them anyway. So in a sense, we'll be actually donating a car. But why not? How can the cops steal a car from the state when it belongs to the state? Do you understand? An allocation, what is that, Tazadaq? Well, that's the time when the judge actually must quote all law he is actually using to sentence, and it is also when we comment on their offers of sentence. So you're free to decline. You're free to decline, folks. Anything done or signed under duress has no legal standing. So to comply under duress is not the same as to consent. So I state for the record, on the record, that I was under threat of physical assault. So I signed under protest and duress. Now I am lodging my appeal to a higher court as a matter of law because all I said or did was under duress and therefore unlawful. That is how I am in contracts. I was psychologically and physically abused. And if I, as beneficiary, accept the sentence, aka the benefit, then they make me executor, which means that it is me who enforce my own sentences. I assign myself to jail. And before I go, court. What about court, Tazadaq? Well, I still will not want to go to court. No one has the authority to tell me what to do. Second, an ecclesiastical depot, if I send that in advance or have someone to go in my place so that I will not inadvertently admit to being the trustee, what's the worst thing that can happen to the representative when he can prove he is someone other than the trust or the trustee? That's the question. So we must show our competence, see, folks, by asking questions, because he who is asking is asked the king, and we ask politely. We can stand at the bar and say, I have an important paper to give to the clerk. I'm not going to go through the bar. May I ask with respect as a matter of law before I cross the bar, what role of each or which role is each of you playing here today with respect to the trust which is being charged? Do you understand? And I ask a second time, then I'll ask a third time. As a matter of law, is the prosecutor acting as executor of the trust? And are you acting as trustee of the trust of this matter? And they'll likely be rude and don't sink to their level. I stand respectfully. It is a matter of law for me to know the roles we're all playing here today before I cross the bar. Will I be crossing the bar and engaging into maritime admiralty law? And if you don't answer, I will be lodging an appeal, and I will appeal now that this matter be suspended so I can request an interlocutory argument and have this question answered. If you are the trustee, then you must have my ecclesiastical depot. Here it is. The judge does not want the case appealed because if it is overturned, then he will pay from his own trust account, which is his commission. So, brothers and sisters, we are of absolutely no value to them until we give them details of the account which they can charge. They cannot gain from us unless we give them the name to a trust to charge. The name must be given. The name, not me, not you, is the only value we could offer. Or you, Tazadaq Shabe. I couldn't possibly be a trust account. So we do not require a name for anything other than commercial purposes, schools, services, doctors, appointments, memberships, bank accounts, benefits, etc. This is why they are so adamant that we carry an ID card. What if we had nothing to identify the trust? The system would actually crash. The system would implode. If they couldn't get any of us to be the trust in order to authorize them to use it, they would starve to death. So we, as just plain old man and woman without names, are no good to them. Understand that. We are not slaves via our bodies. We are slaves only via the account. So in places like California, the people complain that undocumented Mexican immigrants, aka illegal aliens, were causing violent crimes, vandalism, etc. And the cops and the courts were doing nothing about it. Now, it seemed as if illegal aliens were the problem, but the district attorney said anything short of murder, we won't prosecute. See, folks, if only the people knew what he meant, they would actually shift their thinking. They would shift their range from illegal aliens to DA. See, undocumented means that there is no trust account to charge, which is why the government wants them all to have driver's license. The DA, the district attorney, won't prosecute because he can't get anything. And there is no one to charge. A man and a woman cannot be charged. Only the trust account can be charged. And since there is no account due to the documents to create them, there is no way to make money off of these immigrants or these illegal aliens. So murder is different. Murder is a different story because this means the illegals took out of the commercial game someone with an account. And so in that case, the district attorney will prosecute them. Wait until the people of California figure that out. They will figure out what the real problem is of these so-called undocumented Mexican immigrants. See, it's always about commerce, folks. It's always about commerce. What about the cost to repair and compensate? Well, it comes from the public trust, as does everything else, which requires public funding. They want us to be connected to the name, trust accounts, which make up the public trust solely to confiscate our cash. This is tantamount to uninsured drivers or people without passports. We don't really require car insurance or passports because all payments for injury comes from the public trust, which we have already funded, causing us to believe that we are personally liable is how they steal what they refer to as money. So I think the real question is, how can we render worthless the Cestui Que trust account so there would be nothing for them to charge, even if they do track down the account? If we all did this, it would end this insane system. They would prefer to keep it alive, but the only way to do this, once we threaten to kill the account, is to begin to behave honorably and follow the rules. So to find your life, you must lose it. So our life, as they have made it, is commerce. Commerce is your life. The only way to lose our life is to get out of commerce. The only way to get out of commerce is to close the Cestui Que trust account. The only way to close the Cestui Que trust account is to claim our body to be in the divine trust. This will bring their fraud to a screeching halt. You've actually been under the sounds of the voice of Tazadaq. This has been a long video, but it's definitely been strong. So brothers and sisters, thank you for your time. This has been a very, very long video, but share this video. Again, under the video, list the person that you shared the video with. This video needs to go around the world. Tazadaq Shah is signing out. I say shalom, shalom, be safe, wholesome. Tazadaq is out.